Okay, thank you very much. I think we have everybody here. So we'll get started. Good afternoon. Thank you very much for joining me. And welcome to another Bridge Legal and HR Solutions webinar. As you might know, Bridge Legal and HR Solutions is a unique consulting firm that brings employment law and human resources under one roof. We also offer workplace investigations and workplace assessment and human rights related services and other services of that kind to employers across Ontario and also across Canada. If you do want to view our past webinars, they are available on our YouTube page. And if you are looking for additional information about us, you can also check out our website at bridgelegalhr.ca. Okay, as I said, thank you very much for joining us. We're going to be talking about bad faith damages and how to avoid them today. And before we get into the details and the actual topic at hand, I just have a couple of housekeeping items, including an introduction of myself in order to proceed. Okay. So first of all, about me, for those of you who don't know who I am, my name is Jandre Lubicic. I might not look like that picture anymore, but I am still an employment lawyer. I focus on employment and human rights law. My main focus is, of course, on helping employers ensure that they are compliant, but also in litigation matters and similar matters as they may come up for our clients. Okay. Now, in terms of today's webinar, you should be aware that today's session is being recorded. A link to the webinar and the recording will be shared after the webinar. Your cameras are off and microphones have been muted. Please use the Q&A box and please submit any questions using the Q&A feature. We will address them during the Q&A period at the end of this session. There are also live captions available. You can click the Show Captions button somewhere on your Zoom toolbar and follow along using those subtitles. I cannot guarantee their accuracy. Of course, I believe they're automatically generated, so I will speak as clearly as possible while we go through this. Okay. So, what's a law firm without a disclaimer? We do also have a disclaimer that we want to make you aware of. So just so you're aware, these training materials are the property of Bridge Legal and HR Solutions. They are not to be copied, shared, or otherwise distributed. And please be aware that nothing in this presentation should be considered legal advice. Every situation has to be looked at from its own merits. So, if your situation matches some of the things that we're talking about today, you should come and talk to us specifically about your situation rather than taking anything from today as legal advice in order to act on your situation. Please be careful with that. In addition, if you do have specific legal inquiries about the topic today and about in general your workplace matters, please contact Bridge Legal and HR Solutions at info@bridgelegalhr.ca. We're very happy to hear from our clients, and we're also happy to hear feedback about our webinar today and about, in general, anything that you may want to talk to us about. Okay, so now that that's done, let's get into the main part of the webinar, which is, bad faith. So we're going to be talking about a few topics today. Our main topic, of course, is going to be what is bad faith? How do you deal with it? And what you can do to avoid it as well. So for that matter, we're going to talk about what it is within an employment law sphere. There's bad faith out there in many spheres, including employment law, but we're going to be sticking to employment law today. So we're going to talk about what do those concepts mean legally speaking. We're going to cover a few classic decisions that establish the notion of bad faith, as well as some other sample decisions so you can see, okay, this is what the courts have decided in bad faith circumstances in the past. We're also going to cover the practical side of the equation. So, how can you avoid bad faith damages? You might not be able to avoid bad faith claims, but you can avoid bad faith damages. And this is where really the rubber hits the road in this kind of a discussion. Okay, so let's start off with talking about what bad faith is and what is it, where does it come from? So first of all, bad faith is actually a shorthand term And it's used to describe a situation where the employer breaches its obligation of good faith and fair dealing in the manner of dismissal. So, employers have certain obligations when they dismiss employees. As we all know, there's obligations under the Employment Standards Act of call of notice, of payment of wages that are outstanding when you terminate. These are not the obligations of good faith and fair dealing. While they're related to those statutory contractual obligations, they are allegations that arise out of the common law. And in this kind of a responsibility section, employers do have a duty to act reasonably, honestly, and fairly when they terminate an employee. So where you don't act reasonably, honestly, and fairly, you can have risk that bad faith claims may be made against you and may be successful against your company. Now, the bad faith does not come out from the fact that you terminated an employee just from that, right? It doesn't arise just from the fact that a termination occurred. Employers are allowed to terminate employees on without cause basis with notice, as long as there's nothing else precluding you from terminating the employee, like the employee is on a leave of absence for maternity, you can terminate an employee. The termination by itself is not bad faith. It's how you approach the termination that's going to be critical to determining whether or not that termination itself was a bad faith termination. Okay, so we'll start off kind of talking about where does this come from? If it's not an Employment Standards Act requirement, where does it come from? So really, it's not a term defined in any legislation, including the Employment Standards Act, because it is a common law term. It came out of the common law over a long period of development, not just in Canada, but also the United Kingdom. But the seminal case here in Canada, which established this concept, was the case of Wallace and United Grain Growers in 1997. And that was further elaborated in the case of Keys and Honda in 2008. So these principles have been around for some time, a few decades. There have been a lot of claims made, and over the years, there has been a lot of decisions that allows us to kind of see the contours of where does this start, where does it end, what does it mean, what is the potential risk to employers. Okay, so let's start by looking at the Wallace case, since it is kind of the case that started this whole thing, and I think it's to date it is one of the most helpful cases on understanding what really bad faith is and how does it arise in employment law scenarios around termination. So Wallace and United Grain Growers. This is a case, as I mentioned, decided in the late 90s, in 1997. But the actual background of the case goes back to the 1970s. So it involves an employee whose name is Wallace. And he was hired by United Grain Growers, UGG, the less well-known UGG. You can see one of their grain elevators here. He wasn't hired to do any kind of grain-related work. He was actually hired to do marketing. So what happened was, in terms of his hiring, was in 1972, he was discussing with the marketing manager of UGG, coming on board and working for them. In particular, UGG was interested in him because he had 25 years of experience of using a particular press. This was in the days of marketing that was done a lot on paper, so he had the ability to use this kind of a paper press that many other employers didn't. But also, he had a sales-related job. So Wallace told UGG that if I'm going to take this job at UGG, I need assurance of continued employment because, I'm old. I'm at the ripe old age of 45, which was the case at the time. And if I'm going to go and leave my current job, which I'm pretty sure I'll work at until retirement, I need some assurances that I will have a long and stable career here. And UGG, which is not something you see very often these days, actually gave him an assurance. They told him, if you perform well, you can expect to work for our company until retirement. Okay, so not very often do you hear that from employers these days, but that is what UGG told Mr. Wallace. So Wallace works for UGG. He works there for 14 years. During those 14 years, he is actually the top salesperson each and every year. Basically, he is performing at a level that above established levels that the company is doing really, really well. Okay. But those 14 years ended in 1986 when suddenly, without warning, Wallace was given a termination for cause. And the company did not provide an explanation. They essentially told him, okay, well, we have cause to terminate you. Here is your termination letter. Goodbye. You don't get any notice. You get nothing because it's for cause, right? A few days after he was terminated for cause, the employer actually sent him a letter. And the letter said that, it was because you were not able to perform your duties satisfactorily. Now, of course, if you consider that Wallace was a top salesperson for 14 years, to terminate his employment because he was not performing seems somewhat harsh, if one word could be used, but it also seems to lack evidence. And the courts looked at this. So what happened was to Wallace is after this termination, after he discovered that he's being terminated for cause under false pretenses, of course he sued, but he also had emotional difficulties and he sought psychiatric help to care for his mental injuries that resulted from the situation in the at termination by UGG. So he also had very big difficulty seeking alternative work. He was not yet at retirement age, though he was nearing it. So of course he was an older employee, so difficulties of seeking work, in addition to seeking work while experiencing mental injuries from the manner of the employee's termination. And in that case itself, the court, which was the Supreme Court of Canada, in fact, looked at the scenario, and at paragraph 103, it gave us a very good definition of what we need to look at, or what bad faith is in employment law. And I'm going to read this out, and you can see exactly, I think it's very, very persuasive in terms of it makes sense, right? So although the loss of a job is very often the cause of injured feelings and emotional upset, the law does not recognize these as compensable losses, as I mentioned earlier. However, where an employee can establish that an employee engaged in bad faith conduct or unfair dealing in the course of dismissal, injuries such as humiliation, embarrassment, and damage to one's self-worth and self-esteem might all be worthy of compensation depending upon the circumstances of the case. In these situations, compensation does not flow from the fact of the dismissal itself, but rather from the manner in which the dismissal was affected by the employer. So really, it's not just because the employee is upset for losing their job, and it's not just that you terminated the employee as the company. It's how did you do it? Did you do it in a high-handed manner? Did you do it in a dishonest manner? Did you do it in a manner that a person, when they look at your termination, they would think, oh my God, why did they do it this way? Why did they treat this person that way? And the Supreme Court of Canada did recognize in the Wallace case that it's a case-by-case basis. Some cases may cross the line and other cases may not. And it's not even a line that we can really easily draw to say, yes, this is bad faith, or no, this is not bad faith. I will have some examples later, but each and every example that I give you later, and every example that you come across, is going to have a factual component, a legal component, and all of these have to be considered for each case individually. So some cases where in one case it may be bad faith, in another case it may not be the bad faith. You do have to, the circumstances are what makes or breaks the case here. So, we understand now Wallace was mistreated by United Grain Growers in terms of being terminated without any reasonable reason, and was fired for cause. So he was disentitled from notice. He was disentitled from any of the benefits that you get if you were terminated without cause. So what was the outcome? What happened to Wallace after this? So the court finds in his favor. Yeah. He was successful in claiming that the employer had breached his duty of good faith and fair dealing. So therefore the employer had behaved in bad faith. So what happened was that the court actually increased the notice period that Wallace was entitled to. I'm not going to go into the details of how it went through the trial process, etc. But basically, originally he had been granted 24 months. On appeal, the Court of Appeal reduced his entitlement to 15 months. And then the Supreme Court of Canada reinstated the 24-month judgment. Basically, the court said this increased notice period compensates Mr. Wallace for the bad faith conduct of the employer in this case. So we're compensating the employee by increasing the notice period. Now, at the time, that was how they approached it. But what happened in the case of Honda and Keys, which is not as important for the general principle here, but the court changed how they calculate these damages. Rather than increasing notice periods, the court determined that what employees should be awarded were a type of aggravated damages known as moral damages. That is to say, we're not going to be looking at 15 months to 24 months. If Wallace was decided today, maybe we'd still give him 15 months and we might give him some money on top of that in exchange for the bad faith, the employer's bad faith treatment of him at termination. So these bad faith damages, as I mentioned, are called moral damages, and this is how it's mostly dealt with in modern jurisprudence, with some caveat, as I will get to in a moment. Okay, so now we know if you treat an employee in bad faith, you could be subject to paying moral damages to the employee. So what are those? What are moral damages? They're a type of extraordinary damages, as I mentioned, which are granted against an employer who breached a duty of good faith, i.e. who acted in bad faith. That's the shorthand I'm going to use throughout. They are not often granted. In fact, quite often employees fail because it's a very evidentiary and fact-specific claim. You have to be able to prove it. You have to be credible if you don't have written evidence, and it's a high bar to prove this. So while they're often claimed, and they're claimed very, very frequently, as I said, they're not often granted by courts. So, many employers I have seen are on the receiving ends of these claims, and quite often the employer does not even know why they are receiving this claim or what these claims are about. It's possible that an employer will at some point get a demand letter for moral damages from an employee that they thought the termination was routine, and then the employer thinks, well, why is this employee claiming moral damages when we did nothing wrong? Well, the case-by-case basis of moral damages is one of bad faith and moral damages is one of the things that you need to consider. What one person might perceive as bad faith, another person might not, or another person may not complain about. So one reason might be that the employee perceived what the employer's actions were in bad faith, even if the employer really didn't think much of what they did. But it could actually be as well that the employer did behave badly, and there's plenty of case law out there where bad faith was found because employers did behave badly and the employee had a valid claim for that. But as it's, each is assessed on a case-by-case basis, we need to look at the details. We need to look at what was the alleged conduct of the employer that constituted bad faith, and what was, as we'll note in a moment, what happened to the employee as a result. What was the injury to the employee? We know for Wallace, the injury was, well, he lost his severance. He was mentally distressed. He had psychiatric issues after what happened. 14 years of good performance and then terminated for poor performance. That's what led to Wallace's issues in that case and what justified his compensation. So there's a level of judgment that needs to be exercised to determine how their behavior is also going to be perceived by the employee in question when the employer is determining, how do we proceed with the termination meeting? How are we going to action this? Employees who feel especially bad after a termination are particularly upset, or employees who have a bone to pick with the employer. I mean, I've had this, seen this in many cases where an employee has other issues with the employer that are just really blow up when termination occurs, and then those form the basis for a bad faith claim that perhaps were not even on the radar of the employer prior to the termination being decided. There can also be the impact of plaintiff counsel. So one of the things to know about moral damages, unlike wrongful dismissal damages, for example, is that they are tax-free. So if an employee wins in court and they get 6 months of severance or 6 months of wrongful dismissal damages, to call it, at $20,000 of damages for bad faith, moral damages, only the 6-month portion would be taxable against that employee. One of the ways this is used by plaintiff counsel is to actually make the allegation in a demand letter, even if they may not make the allegation later in court, and then use that as a justification to gain a portion of the damages that their client may be entitled to as non-taxable general damages or other type of damages that do not need to be reported to the CRA, do not form income, do not then require deductions. So there is a strategic element to these claims, and this is why I say they're often claimed, they're not as often awarded. And just because an employee comes back to you with a demand letter saying, oh, you treated me in bad faith, does not automatically mean that there was something to that. The situation does need to be looked at on its own merits. Okay, so we know now moral damages are what flows from bad faith conduct. So what are moral damages and how can the employee justify them. So there's ingredients to moral damages. As with anything in law, there's kind of preconditions and a test that needs to be satisfied on whether or not the plaintiff is going to be entitled to the type of damages that the plaintiff is claiming. So for moral damages, there's basically two preconditions. The first precondition is the bad faith behavior. As we already mentioned, the employer breached his duty of good faith and fair dealing in its conduct during the course of dismissal. The employer acted in bad faith. The second question is the impact on the employee. The employer's breach has to cause mental distress or another intangible effect on the employee in order for the employee to justify the award. So you need both. You can't just have bad faith behavior without some kind of an injury to the employee, and you can't just have an injury without some kind of bad faith for the employer. It's an and not an or test here. That we have to consider when we're looking at a bad faith circumstance. So I think one of the best ways to kind of see what bad faith is to look at some examples. So I'm going to go through a few examples of bad faith behavior right now, and I'll tell you sort of what they mean to the extent that they are explainable that way. But also we're going to talk about what is not bad faith, basically conduct that employees claimed was bad faith, but courts later found were not bad faith. So to start off with, what is bad faith behavior? Well, one of the classic ones is misrepresenting the reason for a termination decision. So, for example, you tell the employee that termination is because the company's having financial difficulties, but actually you're terminating the employee for another reason. So a classic case of that was an employee was terminated for physical limitations because they needed certain accommodations at work. Of course, the employer did not say that. The employer told the employee, well, actually, the reason we're terminating is the company's facing financial difficulties. The employer could not then, through documentation, prove that they were facing financial difficulties. So, of course, aside from potentially claiming discrimination in that case, the employee can also claim that the employer behaved in bad faith in termination of the employee's employment. Dismissing an employee because the employee was on the cusp of attaining a benefit or right. So, for example, say you've got an employee with a retention bonus in their contract. So basically, the contract says, Alice, when you hit 5 years of employment, we're paying you $100,000 retention bonus. We really love you. We want to keep you for the 5 years. And now Alice works for the employer for 5 years. And 2 days before the bonus is payable, or 1 day before the bonus is payable, Alice gets a termination letter from the employer telling her, okay, you're being terminated. And maybe they allege cause, maybe they don't, but they say, we're not going to pay you that retention bonus that we promised you. Well, suddenly it looks like the employer might have terminated the employee because the employee was basically going to get a new benefit. And if that's the case, that can be a bad faith scenario. But as I already mentioned, somewhat about a misrepresentation scenario, but firing a disabled employee upon return from a job protected or accommodated leave of absence. This happens quite often. Employee returns from a leave of absence, and maybe they've been away from it for a few years, and the employer's business has changed quite a bit, and the employer looks and says, well, look, we really don't have a job for her, so let's just terminate her right away. Well, you cannot do that. Unless there is a good reason for the termination, unless the termination is legitimate. So if you just do it because you don't like that the employees are returning from a job protected or accommodated leave of absence, that's something that can easily lend itself to claims for bad faith. Attacking an employee's reputation, that goes without saying, going on social media or telling people, okay, look, that guy's bad, that guy's not a good performer, etc., especially if that's not true, of course. Unreasonably maintaining a wrongful accusation on an employee without evidence and communicating that to others. That's a case like, for example, an employee is accused of theft in the workplace and there's no evidence of that, but all the other employees now think that this person is a thief and they've been terminated because of that. Well, that could also lead you to have treated this employee in bad faith, especially if you have no evidence to back up what you're saying in terms of that termination. And one of the classic ones that I see all the time is laying off an employee for lack of work while advertising the role the employee held. So, for example, you terminate an employee and you tell them, we're eliminating that role. That role is now redundant. We don't need it in our organization anymore. And then the employee's gone. And then, a week later or even a month later, you post a job posting that says, oh, we now need somebody for that very position or for a very similar position. Well, it's not likely that if you post it a day later, that's going to be upheld as reasonable. But if you would need to be able to prove that, things changed over the period of that month between the employee leaving that required that role back. And many employers can't do that. So, don't advertise a role that the employee held after terminating the employee and telling the employee that we are, going, removing that role or making that role redundant. This can be malicious. Some employers do it out of malice, but it can also be a case of the right hand not knowing what the left hand is doing. So, make sure that if you're terminating someone, you're not also advertising for that role. Depending on the size of your organization, that's going to be something very important for you to look at. So those are some examples of bad faith behaviors that have been found to be bad faith in case law. Again, don't take this as gospel because it all depends on the circumstances. In some cases, it may be okay. I mean, attacking an employee's reputation falsely is never okay, but in some cases, maybe it's okay, but the circumstances are what matters the most. Okay, so what are some examples of behavior that is not considered bad faith behavior? Well, one is failing to provide adequate termination payments at the time of termination, but correcting that when discovered. The court's not looking to punish accidents or punish behavior which was not intended. So if you found out that you only paid 5 weeks of severance, but the employee was entitled to 6 weeks, and you get an email or something called from the employee, and the employee says, well, why didn't I get 6 weeks? I only got 5 weeks and I've been with you for 6 years. Well, if you go and correct that and go up to 6, well, that's fine then. It's not likely that that's going to be bad faith because you went and took the steps necessary after it was discovered. That also goes into the next example, careless, sloppy, or erroneous behavior. So that's things like bad math, bad calculations. It happens to everybody because it can be complicated to calculate, entitlements on termination, how much vacation pay is accrued, unpaid, how much vacation pay has to be put on the ESA amounts, et cetera, et cetera. There's a lot of calculations that go into a termination. It's more complex depending on how many compensation entitlements the employee has. So, where you're sloppy or where you're erroneous, you're not likely doing a bad faith activity, but, you're gonna want to correct your error. You're going to want to make sure that you're not sloppy, you're not erroneous, because, non-correcting that can make it fall onto the side of bad faith. Providing truthful reasons for termination, even if they may involve negative feedback like poor performance or discussions of workplace misconduct. So this is quite often, employers in Ontario terminate employees without cause, even though, for example, the employee's performance was poor. Well, if you're terminating without cause, you don't have to give a reason to the employee for the termination, but in some cases, maybe it does make sense to give the employee the feedback. Tell them that it was their performance or maybe their misconduct that resulted in the termination, because anything else you say might be untruthful. So, it can cause employees to be more upset or make for a bad exit. So employees don't often bring up statements, misconduct or performance issues during these termination meetings, and they say things like, we're going in a different direction, or there are financial circumstances. But then you have to be careful if the employer later claims constructive dismissal, well, were they really financial circumstances, or was it something else that caused the termination? So truthful explanations are good, false explanations are bad. Alleging cause for termination if the employer had a reasonable grounds for cause, again, not bad faith, even though some employees claim it is bad faith. And that could be without necessarily having all the evidence there, but having a reasonable suspicion that something did happen could justify a for cause termination. But again, if you're going to do a for cause termination, please talk to your lawyer before you do that, whether that's me or whether that's anybody else. They're going to want to look at the scenario very carefully before you terminate for cause. Refusing to negotiate additional severance is not bad faith. Many employers, offer additional severance to the employee, and the employee refuses it, or the employee comes and asks for more severance from the employer because they feel they didn't get enough. You, as the employer, do not have an obligation to negotiate with the employee. You can ignore it. You can say no, thank you, goodbye. Just the mere fact you choose not to negotiate, is not in itself bad faith. But you have to be careful. Make sure you've paid out the employee everything. Make sure that the employee actually received their employment standards and that they received their entitlements under their contract, because that would cause a potential bad faith claim if you fail to pay those. failing to advise employees that they would be provided their minimum standard entitlements in the event they rejected the termination package by the employer. There was a number of case law out there suggesting that if you fail to advise an employee that they will still get their minimum standards if they reject a severance package is bad faith. Courts have more recently found that that's not, as long as you do actually pay what the employee is entitled to, even if the employee is not aware necessarily that they're going to get their minimum entitlements. It is still best practice in all cases to ensure that the employees understand that if they refuse a severance package, they will still get their Employment Standards Act entitlements, even if they reject it, okay? Failing to pay ESA amounts, as I said, could cause bad faith. Delay in processing and returning personal items. Quite often employees leave personal items at work, and just because it takes some time to get that to them does not mean it's bad faith. And delays in processing unpaid vacation pay were also found to not be bad faith, where those delays were, not malicious and not intentional to try to disentitle the employee from an employment status or a contractual entitlement. Okay, so that is bad faith and not bad faith. So that's ingredient one, right? Ingredient one is, did the employer behave in bad faith? Ingredient two is, what was the effect of the employer's behavior on the employee? And that's where we get into mental distress and other intangible effects. So we'll start with mental distress. And what constitutes mental distress then? So as I said before, as I'm saying right now, but moral damages do not automatically flow from bad faith conduct. You need two things: bad faith conduct and that the employee suffers mental distress or another intangible effect. One on its own is not enough. So mental distress was found by courts to not be the same as psychological upset. Really mean being upset because you lost your job. Most people are upset because they lost their job. That on its own is not enough. It has to be serious, prolonged, and greater than ordinary distress and hurt feelings resulting from a termination that every person experiences when they're terminated, that kind of a distress. Most people would say. Mental distress does not include upset, disgust, anxiety, agitation, or minor or transient issues that pass, right? There's some prolonged suffering that has to happen for the employee to justify that they have suffered mental distress. It does not need to be a psychiatric illness, though. It doesn't cross that barrier. It doesn't have to be something where the employee has a diagnosis that as a result of the employer's activities, they have now suffered a psychological injury, okay? It only deals with the symptoms and their effects, not with the actual underlying diagnosis. And in fact, that gets into our next part, which is, what about medical evidence, right? Is medical evidence required? Well, the short answer is that sometimes courts have wanted medical evidence and sometimes they have not. If the employee's own evidence of mental distress is relied upon, so if the employee themselves is testifying saying, I suffered this and suffered that, it's more than just the employee's statements and more than just a scintilla of evidence. You need more than that. So it has to demonstrate a serious and prolonged destruction that transcends ordinary emotional upset and distress. And the evidence, medical evidence can be included, but aside from that, evidence from the employee themselves, from the employee's spouse, family members, and friends about the impact on the employee is going to be relevant and would be something that courts look at to determine, did this employee suffer mental distress as a result of the activities that the employer allegedly did? The trend these days is towards not requiring medical evidence. In most cases, okay, so it's not very likely that courts are going to require mental distress evidence unless there's something special or specific to that case that might prove it. So this is only related to mental distress, but as you recall, if the employee suffers another intangible effect, that can also lead to moral damages for bad faith. So what's another intangible effect? Well, that really is focused on the employee's reputation and suffering that the employee's reputation has as a result of the employer's activities or unsupported allegations. So if it's a loss of reputation, you have to have 3 additional conditions. The employee's reputation must be damaged by the public knowledge of false allegations relating to the termination. The employer does not take any corrective steps. Remember, corrective steps are important. If you take corrective steps, that helps. And did not offer any reasonable excuse for failing to take corrective steps to the damage to the employee's reputation. And the damage to the employee's reputation has impaired their ability to find new employment. And that's kind of the key here is, what the employee might not have suffered mental distress if they suffered another intangible effect. The question is going to be, how much of professional damage did this employee suffer as a result of these activities or these false allegations that the employer made against this employee? Okay, so that's how you get to moral damages. You need to have those two ingredients: the employer's bad faith and the employee suffering or another intangible effect. And when you have those two, moral damages flow. Well, then the next question is, well, what are moral damages and how much? How much do I have to potentially be on the hook for if I'm found to have breached the duty of bad faith and the employee had suffered? Well, that's when we talk about the topic of quantification. So to quantify moral damages, we can look at Honda and Keyes, which provides a good general descriptions of how these damages are legally looked at. They're compensatory in nature. They're intended to compensate the employee for their injury, right? Because there is an injury, this is a compensation for that injury. The quantum or the calculation is determined through an assessment of the actual damages caused to the employee by the employer's behavior. So there is no specific mathematical formula. The court will look at how egregious is the behavior and how much distress did the employee suffer. So, for an example, an employee falsely accused of theft publicly, that would cause them a great deal of mental distress, inability to find work. They'll be awarded higher level damages if the allegations was false than in a case where the employee was terminated for theft, but this was not disclosed publicly to anyone but the employee and the people handling the termination. So, for example, if it's just a private meeting and you accuse them in that private meeting, that's less than if you had publicly accused them of that and other people have found out about it. It might still be bad faith, but it's potential that the damages are going to be lower in the second case than in the first case. So to that end, I've collected a few recent case examples of moral damages for us to talk through. And then once we're through those, we can have our question period. Okay. So one recent example is the case of Krmpotic and Thunder Bay Electronics, which was in 2024, ONCA decision, that's Ontario Court of Appeal. And it was an employee of 30 years, I believe he was a maintenance person, who was returning from a leave of absence for back surgery. Now, the surgery itself was necessary due to workplace injuries that the employee had sustained over the years that he had been working there, 30 years at the Thunder Bay Electronics company. So within 2 hours of returning to work from this leave of absence, the employee was terminated, and the employer offered 16 months of pay as severance to the employee, which is, quite a significant package. But for a 30-year employee, it's not actually on point. In any case, the employee refused the severance, and the employee brought a claim. After all of this happened, the employee suffered back pain, knee pain, anxiety, depression, fear, mental distress, confused emotions, anger, disturbed sleep, worry, frustration, helplessness, and defeat. Those are listed in the case as the impacts on the employee from the employer terminating him within 2 hours of returning to work from a leave of absence. The court did not require medical evidence. The testimony of the employee, family, and others was enough in this case. And I mean, it's one of those cases where it does look like the employer just wanted to terminate the employee and didn't want to keep them there. So this resulted in $50,000, as I mentioned, in moral damages, in addition to any claim for wrongful dismissal damages. So remember, I'm just talking about the moral damages point of this. The employee would still get reasonable notice and damages in lieu of reasonable notice, and could still get other grounds of damage as well, which we'll note in a case to come. Okay, so that's the Krmpotic case. It's very important now. Another case that came out actually just this year in 2026 is Wilshire and Olympic Wholesale. That was an employee of 17 years. It was terminated because of something that, at first reading, many employers would see and think, well, of course we would terminate an employee who did this. he had edited timesheets of unionized employees to top them up. So an employee who didn't work 40 hours would get 40 hours anyway, basically. Think an employee worked 37 hours, he was rounding it up to 40 and editing timesheets of employees in the company. Olympic Wholesale saw this and they considered this fraud and time theft and terminated the employee for cause. But the employee claimed that the 40-hour per week top up was actually an unwritten workplace policy that was designed to comply with the collective agreement. So basically, these unionized employees had a collective agreement that said you get 40 hours even if you don't work 40 hours in a week. And all this employee says he was doing was correcting that and being in line with what this unwritten policy was. I mean, maybe ideally the company should have had a system to handle that, but they didn't. I think the damning part is that other employees did it too, and they were not punished. The only people punished were this employee and the employee supervisor, nobody else. So the court basically said, look, we're siding with the employee. It's not behavioral fraud because you knew this was happening. And in fact, other people were doing it and you did not do anything about it. So in essence, the court found in favor of the employee, even though, it does look on first blush, if you didn't have the background, it looked like the employee was engaged in time theft. It looked like the cause termination was justified. The strange thing in the Olympic Wholesale case is that instead of rewarding damages like in the Krumpotich case or the other case of $50,000 or $20,000 or whatever the amount is, the court decided to increase the notice period from 19 months to 33 months, which is unusual because that's not done anymore after the Honda decision that I mentioned earlier, Honda and Keys in 2008. So it's a very good chance that this is going to be, if it's appealed, I'm not aware that it has been appealed. But if it is appealed to the Court of Appeal, I think there's a good chance that it's going to be overturned based on damages and different damage calculation is going to come out. But it's not very likely that the entire case would be overturned and the employer found to have not done anything wrong in this case. Another case from our recently gone company, Hudson's Bay Company. This was in 2022. It's Paul and Hudson's Bay Company. And this was an employee of 28 years. And as you might imagine, this was right after COVID. It's 2022. So the employee was terminated kind of around the restructuring of Hudson's Bay business after the COVID disruption had happened in 2020. The employee was terminated without cause. He was offered a 40-week separation package, and the employee refused. In response, the Hudson's Bay Company said, okay, well, if you're refusing the severance package, here's an offer of employment for a lower decision, for a lower position, which was substantially lower than the position that the employee had held for 28 years. So the employee sued for wrongful dismissal. The court did find that the Hudson's Bay Company had engaged in bad faith conduct, and there was a few grounds on which they found that. So first of all, the employee was walked out the door immediately on termination, and that was seen as insensitive by the court, given that the employee was there for 28 years. There was no security or other concerns that could be identified by the company. So, he was walked out and humiliated to some extent without any reason to do that on the termination date. On top of that, the Hudson's Bay Company paid the Employment Standards Act sums incorrectly. They processed the Mr. Pohl's termination pay as a salary continuance instead of a lump sum. The Employment Standards Act requires lump sum payments. So if you incorrectly pay out Employment Standards Act sums, that can help an employee make a claim of bad faith against you. Hudson's Bay also failed to issue a record of employment on time. And when it did issue a record of employment, which it did twice, it issued 2 incorrect records of employment, and that can impact an employee's ability to receive employment insurance. And on top of that, the final issue that the court kind of had words for Hudson's Bay about is that the offer of the lower position was specifically designed by Hudson's Bay Company to deprive the employee of their common law entitlements and to cancel the employee's benefits by reducing his hours. The contract did not contain any minimum guaranteed hours of work. So if the employee had accepted it, it might well have been without hours of work anyway, despite accepting this offer of employment from Hudson's Bay that I believe they offered to attempt to structure a defense that the employee failed to mitigate by looking for alternative work or failing to accept this alternative position, which I guess the Hudson's Bay thought was comparable, but clearly the court did not agree that it was comparable. The employee was awarded $55,000 as moral damages. And the court did not require medical evidence in this case either. It was stated that the award was based on the fact that the employer knew that its conduct would cause mental distress to the employee. So again, another case where the $55,000 could have been avoided if this had been structured properly. Another case law, a bit of an older case, and it's the last case I just want to mention, but it also just shows how there may be multiple heads of damage that may result from the same behavior. So this employee, Johnston, was a building inspector for the municipality of Aaron Elderslie, and he was accused of having a conflict of interest by concealing that he was inspecting building that he had previously designed. I guess he was an architect. I did not look into that part. The court found that the employer knew that the building was designed by the employee. So, I mean, that doesn't make much sense. But in addition, it also found that when the employer investigated the conflict of interest, they used evidence they knew was tampered, and they failed to call witnesses that could have spoken to the event. So basically, the investigation was set up against the employee. There was no way that the employee could have come out of the investigation looking good. So it was a stitch up by the employer is what the court saw it as. And the result of the employer's issues here was significant to this employee because his career never recovered. And if you look it up, this actually received negative media coverage. The employee could not find other work elsewhere. And the employee's marriage actually ended due to the events that occurred and due to the employer's conduct in this case. Interestingly, the employee was awarded damages, moral damages for bad faith, but also $100,000 at that, but also $200,000 for punitive damages. And punitive damages are separate from moral damages. I'll talk about punitive damages just quickly since they do come up and go hand in hand, but they are different from moral damages. So punitive damages result in cases where the court wants to punish the employer. So, moral damages are focused on compensating. As I said, they're compensatory for mental distress relating to the manner of dismissal, while punitive damages are focused on punishment, deterrence, and denunciation. So they're focused on punishing the defendant's wrongful conduct. This can be claimed in addition to moral damages, and the same acts that can justify moral damages can, in some cases, justify punitive damages if such actions are sufficiently malicious, oppressive, or high-handed on behalf of the employer. So the courts, when they're looking at punitive damages, they're not looking at, how much injury did the employee suffer? They're looking at how bad was the conduct of the employer. Is it so bad that this court needs to denounce this employer to make sure that other employers in the future don't behave in this way? So in the case of that we just spoke about of Johnston, that was something that the court looked at. So while the same actions by the employer justified the award of the aggravated $100,000 moral damages award and the $200,000 of punitive damages. If the employer had investigated properly in that case, if the employer had terminated this person properly with payment of notice, etc., I mean, this case might have been worth $100,000, but in the end, the employer shelled out close to $500,000 in damages in this case, all because of the steps that the employer took when they terminated this employee. Okay, so we're coming up on the end, so let's talk about how do you avoid this. So, I mean, I tell this to all my clients. I tell this to everybody that I meet. You must document, document, document. And sure, you document everything. If you've got performance or misconduct discussions, even if it's a verbal warning, have a written documentation that on such and such a date, this employee wasn't warned because they did X, Y, Z, right? Have that documented because you never know when the written information may be very important. As we found out in the case with the employee that was changing timesheets and citing an unwritten policy as the reason for changing timesheets, you should have your policies in writing. Employees who are subject to unwritten policies can interpret them in ways they like, misinterpret them, or misunderstand the limits of those policies. So not only should you have the policies in writing, they should be clearly communicated to employees, and you should keep dates and records of when those employees are informed of those policies. If they're signing acknowledgement, make sure they sign and date the acknowledgement so look, they read this, they understood it, there should be no excuse for them to now not be complying with it. workplace investigations, interviews with witnesses, allegations, all those investigation clauses should be in writing. And you should keep documents as long as required by law and needed for the purpose, including post-employment. In case there's litigation that comes up, it's much more convincing to a judge when you have something contemporaneous in writing than for something that, the employer said one thing and the employee said another thing. And now the judge has to figure out, well, who do I find more credible in this case? Another set of tips is that you should always avoid misrepresenting the reason for dismissal in all cases. Always avoid it, because that can just lead employers to get the wrong idea and make inquiries that they wouldn't otherwise made if you hadn't told them that. And then you can potentially have an employee come back and claim bad faith. Again, they need to prove that it was both bad faith and that they suffered mental distress. But because medical evidence is not necessarily required, some employees can do that. So you have to be very careful when you're terminating an employee to be candid and forthright to those employees. As I mentioned already, but it bears repeating, termination meetings have to be sensitively and privately conducted to avoid public humiliation, embarrassment, or unnecessary injury to the employee's reputation. If somebody does not need to be at the meeting, if somebody does not need to know about why an employee is being terminated other than to process the payroll or to attend the meeting, to, do the documentation, they should not know about that, right? They should not know the details where those details might injure the employee's reputation and where the employer doesn't have sufficient evidence to later defend against such a claim. Do not walk out long-term employees if there is no justification to do that. I've always saying this: if there's no health and safety risk, if there is no risk that the employee is going to take something you don't want them to or something like that, don't walk them out. That's what happened in the Hudson's Bay case, and it led to an increase in damages. All outstanding wages, severance, and termination pay has to be paid in a timely manner under the Ontario Employment Standards Act. So you need to make sure that those are paid timely, and you need to pay them the way they are required to be paid. If you recall, one of the issues in the Hudson's Bay case is that he was not paid his entitlements as a lump sum. He was paid as a salary continuance. Should not have done that, right? Should follow Employment Standards Act at all times. And release an accurate ROE. Employees are entitled to a record of employment every time that there's an interruption of their earnings. So that means if they go on a leave of absence, if they're not at work for 2 weeks, 3 weeks, forever, for any period of time that exceeds, I believe it's a week, you have to make sure that the employee gets a record of employment and that the record of employment is issued on time and is accurate. It can affect their EI entitlements, which will cause employees to definitely be upset if they cannot access those. And finally, if you're terminating for cause, document, investigate, make sure that you do not make baseless accusations, because cause is not going to be justified. And also, if you do terminate for cause, make sure that the employee knows what is the behavior that justifies cause. If you don't justify cause, you're not going to be able to then show later down the line, okay, well, this was the reason, if the employee comes in and sues you for wrongful dismissal. That's not a situation you want to be with, and you want to make sure that the employee knows what the reasons for cause was, and you have documentation to back up those reasons in the back. As with in general, all workplace investigations, if you're investigating workplace harassment, if you're investigating workplace violence, make sure you do that in an unbiased manner. If the boss of the company is accused of workplace harassment, it may not be appropriate for somebody in the company to investigate. It may be somebody external, like an external investigator, who needs to be brought in, because there's going to be a question of the fairness and the unbiased nature of that investigation that can come up and can be relied on by employees to potentially claim bad faith if they feel that investigation was not fair. Do not terminate employees directly after an accommodated or legislative leave of absence. Sometimes it's unavoidable. Make sure you look at each case on its specific. The general rule to me is don't do it if they're just coming back, and certainly don't do it 2 hours within 2 hours of them returning, as happened in the Kumbutic case that we discussed earlier. Do not terminate maliciously to deprive employees of upcoming entitlements, as in the example I explained earlier with the retention bonus, but in other examples too. Employee gets 3 weeks of vacations when they hit 5 years and you terminate because of that. Don't do that. That can result in bad faith claims. And again, and I think this bears repeating, you have to document everything. Make sure that your documents are kept for the amount of time required by the Employment Standards Act. But I can't tell you how many cases I've encountered where there was a good reason for a termination, but there was no attempt to document discussion by the employer, and suddenly it's become a case of credibility. Does the judge believe the employee more than the employer in that case? And a balance of probabilities mean that the judge is going to decide 50% plus one, which side is more credible in this case. If you have documentary evidence that shows contemporaneous documentary evidence that a judge can look at in a litigation, that's going to be something they much prefer than looking at what did the employee say, what did the employer say in their testimony in front of me today, because that is a harder judgment call to make than contemporaneous written documentary evidence. Okay, so that actually brings us to the end, and I'm just going to move to the question slide. So I'm just looking at the open questions over here, and it looks like I have been very, very good in this webinar because there are currently no open questions. So since that is the case, I am going to thank everybody for attending. But if you do have any questions about the webinar today, or if you do have any questions about Bridge Legal and HR Solutions, please do reach out and contact us. Our email right there on the screen is info@bridgelegalhr.ca. Our phone number is 647-794-5442. There's also going to be a post-webinar survey that we would really appreciate if you could fill out. And don't forget, as I mentioned, check out our website and check out our YouTube page for past webinars, and also check out our website and our LinkedIn profile for future webinars, as I'm sure we'll be hosting more to come. So with that, thank you all very much for attending. I hope everybody has a great day. And one last thing, you will be getting a recording of this as well as the slides in PDF format shortly after this presentation. Again, thank you very much. Have yourselves all a great and wonderful day. Bye-bye.